counsel for the prosecution, trial lawyer Alice Tsago, associate trial lawyer Inbal Javolowski, and assistant legal officer Mariana Gutierrez. Your Honor, in addition, associate trial lawyer Laura Varlich, who could not be present in court now due to COVID-19 restrictions, will be introduced after the break, and our case manager, Grace Go, is working remotely. Thank you.
Thank you very much, Mr. Prosecutor. The defense team, please.
Good morning, Your Honor. Michael Carnavas for Mr. Gicheru, lead counsel. With me is Susanna Tomanovich, associate counsel. Noah Elmont, legal assistant, and Daria Machete, our case manager. Thank you.
Thank you very much, Mr. Carnavas. And for the record, I take note that Mr. Paul Gicheru is in court. Good morning, Mr. Gicheru. Now, for the members of the public, let me quickly introduce myself. My name's Amiata Maria Samba, and I am the judge in this case. As you are aware, we are here today for the opening of the trial of Mr. Paul Gicheru. I'll open with a few preliminary remarks, and then the charges will be read. We then intend to hear opening statements from or by the prosecution. As an introduction, I wish to provide some short background information to this case. On the 31st day of March 2010, Pretrial Chamber 2 granted a request by the prosecutor authorizing an investigation into the situation in the Republic of Kenya. The proceedings before this court is a third active case arising out of that situation. The prosecution alleges that witnesses related to the proceedings of another case emanating from the Kenya situation, in the case the prosecutor against James Samuel Ruto and Joshua Arap Sang, have been influenced pursuant to Article 70 of the Rome Statute. On the 15th day of July 2021, Pretrial Chamber A issued its decision on the confirmation of charges in this case. Therein, it confirmed several instances of alleged interference of witnesses. These are the charges brought before this chamber. In Decision 185, the chamber set a deadline of the 21st day of January 2022 for the filing of any motions requiring resolution prior to the commencement of trial. The chamber notes Rule 1342 of the Rules of Procedure and Evidence. The chamber will now ask the parties whether, save any pending request with the chamber, they have any remaining objections or observations concerning the conduct of proceedings which may have arisen since the confirmation hearings. Now be mindful in accordance with Rule 134(2). No such objection or observation may be raised during the trial proceedings without the leave of the court. I now ask the prosecution.
May it please the court, Your Honours, there are no objections from the prosecution. There is one pending request that the prosecution noted in its trial brief, and that was a request for the chamber to consider legal recharacterization of the charges to the extent of the legal contributions of certain of the alleged intermediaries of the common plan, which the pretrial chamber found did not rise to the level of essential contributions. This is a matter I will address in my opening address, so I'll say nothing further on that at this point. But the matter is already on in our trial brief.
Thank you very much. Mr. Carnavas, please.
No objections, Your Honor. We're ready for trial.
Thank you very much, Mr. Carnavas. So in accordance with Article 64(8)(a) of the Rome Statute, the charges will now be read to the accused following which Mr. Gicheru will be afforded an opportunity to make an admission of guilt or to plead not guilty. This is the public redacted version of the charges, in which very limited information is redacted. The Chamber notes that Mr. Gicheru and his defense team have access to the unredacted version of the charges. Madam Court Officer, could you please read the confirmed charges?
Thank you, Madam President. The confirmed charges against Paul Gicheru are: first, pursuant to Article 25(3)(a), jointly with another person or as an individual; 25(3)(b), soliciting or inducing; 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0397 by small Roman 1, offering to pay him a bribe of 5 million Kenya shillings in cash installments; small Roman 2, and or threatening him, and or small Roman 3, by actually paying him a total of 1 million Kenya shillings, in order to influence him to withdraw as a prosecution witness and cease cooperation with the ICC, to sign an affidavit to that effect, and or to locate, contact, and or corruptly influence P0516 on behalf of the Common Plan members, committed during the period April 2013 to January 2014 at a redacted location in Kenya. Second, pursuant to Article 25(3)(a), jointly with another person or as an individual; 25(3)(b), soliciting or inducing; 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0516 by offering him to a bribe of 800,000 Kenya shillings in installments and actually paying him a total of 500,000 Kenya shillings, to withdraw as a prosecution witness and to sign an affidavit withdrawing his prior statement to the prosecution, committed during the period of April to May 2013 at a redacted location in Kenya. Third, pursuant to Article 25(3)(a), jointly with another person, or 25(3)(b), soliciting or inducing, or 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0613 by offering to pay her a bribe, the amount of which would be subject to negotiation, to influence her to withdraw as a prosecution witness, committed during the period April to September 2013 at a redacted location in Kenya. Fourth, pursuant to Article 25(3)(a), jointly with another person or as an individual; 25(3)(b), soliciting or inducing; 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0800 by offering to pay him a bribe of between 1,500,000 and 2,500,000 Kenya shillings, in order to influence him to withdraw as a prosecution witness, to sign an affidavit to this effect, and to locate and corruptly influence other prosecution witnesses, including P0495 and P0613, committed during the period May 2013 to March 2014 at a redacted location in Kenya. Fifth, pursuant to Article 25(3)(a), jointly with another person; 25(3)(b), soliciting or inducing; 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0495 by offering to pay him a bribe of between 1,500,000 and 2,500,000 Kenya shillings, and employment to withdraw as a prosecution witness in the Ruto and Sang case, and corruptly influence other prosecution witnesses, committed during September 2013 and at a redacted location in Kenya. Sixth, pursuant to Article 25(3)(a), jointly with another person, 25(3)(b), soliciting or inducing, 25(3)(c), or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0536 by offering her a bribe of between 1,400,000 and 1,600,000 Kenya shillings in exchange for her withdrawal as a prosecution witness committed during the period May to September 2013 and at a redacted location in Kenya. Seventh, pursuant to Article 25(3)(a), jointly with another person or as an individual, 25(3)(b), soliciting or inducing, 25(3)(c), or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0341 by small Roman 1, offering to pay him a bribe of 5 million Kenya shillings and other financial benefits. Small Roman 2, actually paying him between 1 million and 2 million Kenya shillings. And small Roman 3, intimidating him in order to influence him to refuse to become a prosecution witness if asked to do so, to cease to attend redacted, to sign pre-prepared or dictated affidavits recording his withdrawal from the ICC process, and or to locate, contact, and or corruptly influencing other prosecution witnesses committed during the period 24 April 2013 to mid-April 2014 at a redacted location in Kenya. Eighth, pursuant to Article 25(3)(a), jointly with another person or as an individual, 25(3)(b), soliciting or inducing, 25(3)(c), or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0247 by small Roman 1, promising him at least 2 million Kenya shillings. Small Roman 2, intimidating and threatening him multiple times, including at gunpoint. And small Roman 3, paying him 30,000 Kenya shillings to induce him to withdraw redacted, to record a false video stating that the ICC attempted to coach him to give evidence against Mr. Ruto, to sign a blank piece of paper, and to locate, contact, and or corruptly influence other prosecution witnesses committed during the period April to May 2012 to 2014 at a redacted location in Kenya.
Thank you very much, Madam Court Officer. Now, can Defense Counsel, Mr. Canavas, can you please confirm that you have explained the nature of the charges to your client, Mr. Gicheru, and his right to make an admission of guilt or plead not guilty to the charges?
Good morning again, Your Honor. Yes, we have fully explained all of his rights, and he intends to go forward with the trial because he maintains his innocence. Thank you.
Well, thank you very much, Mr. Canavas. Mr. Gicheru, can you rise, please? Now, do you understand the nature of the charges read out to you today?
Yes, I do, Madam President.
Do you make an admission of guilt with respect to any of the charges?
Not at all. Madam President, for the record, I plead not guilty. Not guilty.
Respect of all the charges?
Yes.
Thank you very much.
Thank you, Madam President.
You may be seated. We will now turn to the opening statements. The prosecution will commence its opening statement today and have been allotted 1 hour. The prosecution, you may now make your opening statements, please. Thank you very much.
Your Honor, the International Criminal Court was established to end impunity for those responsible for the most serious crimes of concern to the international community. It was established to seek justice for the victims of such crimes. It was established to seek the truth. But in order to establish the truth, victims and witnesses must be able to testify freely and honestly. And when their evidence is perverted through corruption or intimidation, the truth is obscured and justice is denied. The prosecution brings this case against Paul Gicheru to protect the integrity of the court's proceedings from offenses against the administration of justice, to punish those responsible, and deter future offenders. We seek to preserve and strengthen public confidence in the court and the expectations of those who look to the court to establish the truth and deliver justice. Those who would seek to undermine the court's ability to provide redress for the victims of mass atrocities cannot be allowed to prevail. They must be held accountable. Your Honor, the investigation and prosecution of William Samoy Ruto and Joshua Arap was beset from the outset with witness interference and intimidation problems, which continued up to and throughout the trial. In dismissing the charges against those two accused, the judges in both the majority and minority opinions of the trial chamber condemned the levels of witness interference, which had made it impossible for the chamber to ascertain the truth. The most egregious and damaging instance of such witness interference, with the accused, Paul Gicheru, allegedly at its center, commenced in early 2013 and continued throughout the trial. This interference caused the Office of the Prosecutor to start an investigation in parallel with the Ruto and Sang trial into numerous reports of witness tampering. That investigation allowed the prosecution to uncover and document the commission of the offenses that form the basis of the case that is now before this chamber. The evidence gathered in the investigation will show that the accused managed and coordinated a scheme to identify, locate, and corruptly influence actual and potential prosecution witnesses. This was done through a combination of bribery and intimidation. The actions of the accused and his associates led directly to the withdrawal and recanting of no less than 4 vital prosecution witnesses in the Ruto and Sang case. The efforts of the accused and his associates to influence corruptly a further 2 witnesses were only thwarted because the witnesses they targeted reported this to the prosecution. While the prosecution does not allege that the accused was himself directly involved in the disappearance and presumed death of another prosecution witness, or in the murder of a prospective defense witness and a former prosecution intermediary, Meshach Yabe, both of these individuals, as the narrative of the case will show, were caught up in the witness tampering scheme. The accused and his associates may not have been the only persons responsible for witness intimidation and tampering in the Ruto and Sang case. However, the evidence will establish, beyond a reasonable doubt, that they were responsible for the offenses charged in this case. This trial, therefore, represents an important step towards holding those responsible for witness interference in the Kenya cases accountable for their actions and achieving some measure of retribution on behalf of the victims who were denied justice. The prosecution notes that 2 further suspects for whom arrest warrants have been issued for the same offenses remain at large, and we call upon the Kenyan authorities to take all necessary steps to surrender these 2 suspects to the court without further delay. Your Honor, I yield the floor now to Senior Trial Lawyer Anton Steinberg and the prosecution team, who will outline in detail the case that the prosecution will present to establish the guilt of Paul Gicheru.
Good morning again, Madam President. May it please the Court. The prosecution will now outline how it intends to prove the charges that have been confirmed against the accused. I will present a general overview of the prosecution case and how it will prove each of the 8 confirmed charges. My colleague, Ms. Zago, will then outline the evidence that will be presented on the accused's individual criminal responsibility. The prosecution does not propose to address in detail the offences charged, which are fully explained in the document containing the charges and have just been read out by the court officer, although I will briefly summarize these for the benefit of the watching public. Nor do I propose to repeat the legal arguments that are advanced in the prosecution's trial brief. Rather, we will focus on the evidence that will be presented and how this will demonstrate, beyond a reasonable doubt, that the accused committed the charged offences and his criminal responsibility. As confirmed by the pretrial chamber, the accused is charged with 8 counts of corruptly influencing prosecution witnesses in the Ruto and Sang case in contravention of Article 71C of the Rome Statute. This was done through a wide-ranging and concerted scheme of witness interference over the course of almost 2.5 years. The accused bears criminal responsibility under several possible modes of liability: direct, indirect, and accessory. In this opening address, the prosecution will focus on the accused's criminal liability by way of his direct and personal perpetration of acts of corrupt influence, as well as his essential contributions to a common plan to do so. The common plan confirmed by the pretrial chamber encompassed the identification, location, and contacting of prosecution witnesses and potential prosecution witnesses in the Ruto and Sang case, offering and paying them financial benefits, and threatening or intimidating them, all to induce them to withdraw as prosecution witnesses in that case, to refuse to cooperate or to cease cooperation with the ICC, and to recant the evidence which they had provided to the prosecution. The common plan group comprised of a number of persons who undertook specific roles. Some, including the accused, fulfilled the role of managers who organized the activities of other common plan members, arranged financing, and negotiated bribe amounts with witnesses who were corruptly influenced. Intermediaries were responsible for locating and contacting witnesses and persuading them to meet with the common plan managers, to be bribed or intimidated. And still others, while not confirmed as members of the common plan, were associated with it and made contributions to the commission of at least one offence charged. And as I noted earlier, Your Honour, the prosecution notes in this regard that it has provided submissions in its trial brief that the pre-trial chamber, with respect, mischaracterized the contributions of certain of these associates and invited the trial chamber to exercise its power to legally recharacterize these contributions as essential and to give the defence notice of this possibility pursuant to Regulation 55.2. In fairness to the defence, the earlier this notice is given, the better it would be for them. I will now briefly touch upon some of the main types of evidence that the prosecution will present in support of these 8 counts. I will also provide some snippets of this evidence demonstrating how offences were committed and the role played by the accused in their commission. I am conscious, Your Honour, that we are in public session and I have applied the necessary redactions to these extracts. I will also not read out the ERNs which are reflected on the extracts, and I can provide a copy of this presentation to the chamber and parties immediately afterwards. Starting with count 1. Since witness 397 is unavailable to testify, the chamber has granted the prosecution's request to submit into the record his prior recorded testimony. This evidence demonstrates how he was corruptly influenced and recruited by common plan intermediaries Yabay and Bet. He explains as follows. Yabay and Bet act like brokers. They identify witnesses and tell that group, and then they facilitate by giving of money, and they also receive their own remuneration. The evidence further demonstrates how he was taken to meet managers Gicheru, the accused, and Samatwo, and relates the events as follows. Starting at line 82, I quote, "And he told me," he being the accused, "and he told me that they'd received a report that I was a witness. And he told me that if that was the case, they asked for my support, for me to withdraw from the case." And he quotes, "Honorable Ruto really requests that you try to bring in any witnesses that you know, and then we'll give them something." From line 105. "So I asked him, what do they offer if I withdraw from the court, from the case? And he asked me, why don't you yourself speak? And I told him I wanted 10 million Kenyan shillings. Then we locked horns over it, and he sweet-talked me and so forth, until we arrived at 5 million. He promised me that he would pay me in installments. That month, they paid me 1 million. They gave me 600,000 first, and then later on he gave me 400,000. So that was 1 million. And throughout that quote, the he being referred to is the accused. P397 further details how he was instructed in turn to recruit witness P516 to be bribed, to which I will return under count 2. The prosecution will present the following corroboration for the prior recorded testimony of P397. Starting with bank records. The bank records will confirm that the witness deposited 2 large sums of money into his bank accounts on dates corresponding with the dates on which he says he received payments from the accused. Firstly, on the 27th of April 2013, he deposited an amount of 500,000 Kenyan shillings, having explained that he spent the other 100,000. And 3 days later, on the 30th of April, he deposited a further 400,000 Kenyan shillings, bringing his bank balance to just shy of 900,000 Kenyan shillings. Prior to these deposits, the balance on this account was 297 shillings. Phone records will confirm these 2 deposits as they reflect text messages from the bank confirming these 2 deposits. Phone records will also corroborate his contact with the accused, whose phone number was recorded in the witness's contact list. The number reflected in the contact list corresponds with numbers that may be found on the accused's business cards and letterheads. We will also produce a letter of withdrawal sent to the prosecution by the lawyer to whom he, the witness, was referred by the accused. We will prove recorded calls between the witness and the accused, and also with common plan intermediary Yabay, the contents of which we say are inconsistent with innocence. And we will present the testimony of other witnesses, including P516, P613, and P341, who will provide corroboration for the version of P397. P516 will confirm that P397 took him to meet the accused, who paid him. P613 will confirm receiving reports from another common plan intermediary, P579, that he, that is 397, was paid 500,000 Kenyan shillings by the accused. And P341 will provide the following evidence. I also saw P397 and P516 at Gicheru's office many times. I spoke with both of them, and they had told me that they both received money but they both had told me that if they did not receive all their money, they will return to the ICC. I move on to count 2. The prosecution will present the evidence of P516, who will testify that P397 took him to meet Gicheru, as I mentioned a moment ago. He says the following from line 285. Yeah, so what happened when I met up with P397 was that he phoned and then I had a meeting with him at a hotel. We met and he told me that the next day we were supposed to go and meet a person called Paul Gicheru. The interviewer asks, okay, and for what purpose? He replies, he told me that Gicheru was giving out money. The interviewer asks, okay, and why was Gicheru giving out money? The response, P397 said it was money for witnesses. When P516 met with the accused, the latter offered and subsequently paid him money. Evidence reflects as follows. Tell us about that discussion about money. The witness says, yeah, I spoke to him, him being the accused. We agreed, give me 800,000. But he didn't give me everything. He gave me 500. Moving on to the corroboration for the evidence of P516. The prosecution will also present the following corroboration, starting with the prior recorded testimony of P397. I quote from line 593. I beg your pardon, 594. So I heard Gicheru telling Meshach Yabe, you'll go and look for him. Meshach told him, no, I think he sometimes speaks to 397. Perhaps. Then later on, Meshach told me, you do this. Go and talk to him. I just went to P516 to find out if he really was a witness, or whether it was propaganda. And carrying on from line 600. I found out that he really was a witness. So I brought him in. I told Gicheru to talk to this person. I went out and they talked. From line 814. Afterwards he told me, when we met, he told me that he'd been promised that on a certain day he could go and collect money, and I think he really did go and collect it later on. The interviewer asks, okay, did he tell you how much it was? And he responds, I think P516 got around 500,000 or 800,000 shillings. I've already mentioned the evidence of P341, that he saw both of the witnesses at Gicheru's offices. And I've also mentioned the report from Common Plan Intermediary P579 to P613, confirming that Gicheru paid a number of witnesses, including both P397 and P516. I move on then to count 3. In this count, the prosecution will present the evidence of P613. She will testify that she was approached by Yabe and at least 6 other Common Plan intermediaries and associates on separate occasions. This included approaches by Common Plan intermediary P579, which he describes as follows. P579 told me to tell them how much I want. P579 was told to come to Kampala with a phone so we could meet and I could talk to those people over the phone. He was given instructions, P579 was given instructions from Gicheru to go to Kampala with the phone. P579 told me that this group are fearing me and that is why they are doing this with the phone, because they are not trusting me and think I will report it to those people who I knew to mean the ICC. She was also approached by a former prosecution witness and Common Plan associate P495. She describes this as follows. P495 told me that Gicheru has been given all the authority. P495 told me when you are given money, they have offered protection because they don't want you going back to the ICC. I asked P495, so is it says is to Gicheru. I think it should read is it Gicheru. So is it Gicheru who is going to finish this thing with us? And P495 replied, yes, they want to meet with us tomorrow. Moving on to corroboration. The prosecution will present recorded conversations with both Common Plan intermediaries P540 and P579. I'll start with the latter, who told her the following. P579. No, these people have a network. Then there's unintelligible words, and he carries on. They have a chain of command. P613. Oh, a chain of command. P579. Now, I've been shown how it works. If they want to call you, then this one will call the other, and then the next, until it gets to you, just like that. From line 106. For people like you who are far away, then you will have to come to Nairobi. P613. To be given cash. P579. You will need to talk first and discuss until you agree. And then again from line 112, P579, you will be given clean cash, P613, and you will be told never to put it in a bank account, which he confirms. Then there's a recorded conversation with the former witness and Common Plan associate P495. He speaks about how he told the accused that he will go and come with that lady, referring to P613, after which he would take his share. P613 asks him, who is in charge? And from line 122, he's in Eldoret. He's the one who is giving it out. P613, is Gicheru the one giving it out? P495, yes. P613, who is he with? P495, I don't know. I was not told the next one. P613, is he with the one who was CDF chairman or Simatwo? P495, there is one who is superior, and I wasn't told who that is.